Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us this afternoon Vadim Glozman. Welcome to the show, Vadim.
Thanks for having me. Looking forward to our conversation.
So, Vadim was a learned criminal defense under Eddie Jensen. And in case you don't know, he was a pretty celebrated defense attorney in Chicago. The Chicago Tribune called him the Dean of Chicago Defense Attorneys. And he represented everyone from R. Kelly to Rod Blagojevich. Now, Vadim Glozman runs his own firm, recently won a full acquittal in the R. Kelly federal trial for a co-defendant facing conspiracy charges. Now, you interned at Cook County State's Attorney Office and walked out wanting to defend people being prosecuted. What happened in that building?
There was just something about seeing people with their back against the wall and it seemed like everyone in the world was against them and just wanting to be in their corner, wanting to, be the one fighting for their rights. I think everyone kind of knows what it feels like when you feel like you're alone in a situation. It's nice to have someone by your side. And that was more intriguing to me than trying to put people into jail.
So Eddie Jensen was pretty famous, particularly for his theatrics. So he once cracked his cane over a defense table to wake up a sleepy courtroom. What's the most outrageous thing you saw him do in court?
That's a good question. Probably some of them I shouldn't say. I know one of the things, and we were talking about it earlier, is he liked to mess with prosecutors. And if they would call him Ed Jensen, he would complain to the judge that it was actually Gensen. And if they started calling him Gensen, he would complain that they're calling him the wrong name and it was Jensen. I know there was another time the prosecutor's table is always closer to the jury box. And every day of trial, he would move the table just an inch further away from the jury box. So by the end of the trial, they were as far back as the defense attorney's table was.
So you started working with Jensen in 2012 and stayed through his retirement. What's the single best lesson that he drilled into you?
Best lesson I learned from him was it's easy to look at a factual scenario and see what everyone else sees. A good lawyer can look at it and read between the lines or frame it in a way without changing the core facts, but framing it in a different way that people can look at it. And that's something I've carried with me the entire time I've been practicing. That's what differentiates me from other lawyers is I can take facts that look one way on their face and make them seem like something else to a jury or a judge or whoever I'm trying to convince.
So Jensen was famous for, and this sounds crazy, for almost never taking clients who wanted to cut a deal. Is that your approach too?
No, that's where I'm different from Eddie. One of the articles about Eddie describes him as a hungry tiger with a raw steak when he sees a case. I think the way cases are prosecuted now, I think is significantly different than when Eddie was in his heyday. There's a lot more technology. There's a lot more written communication, especially in white collar cases that I do. There's text messages, emails, Slack messages, recorded calls. So a lot of times it's a lot harder to defend a case. You can't just call someone a liar. So I like to say it's an individualized approach to my clients. I could have 5 people charged with the same crime. It doesn't mean it's going to be the same approach from all of them. For some of them, the right decision is to go to trial. Some, it's to try to work out a deal that's going to preserve their future.
Okay, so you represented R. Kelly's former business partner, Darryl McDavid, in the Chicago federal trial. When a case is that radioactive publicly, how do you decide whether you're going to take it or not?
That one, we never thought about pleading guilty. From the beginning, the case was shaky, at least we thought, on the government side. All the facts that they were alleging happened more than a decade before. Their 3 main cooperators all had competing stories, and there was never going to be a good deal on the table. So that case we knew from day one was going to go to trial.
So the jury convicted Kelly, but acquitted your client on every single count after 5 weeks of trial. So what was the moment, and this may be a silly question, what was the moment you knew the jury was with you, or do you ever know a jury is with you?
Anyone who's tried a case knows that it's a roller coaster. After one witness, you think you're winning. After one witness, you think you're losing. I can tell you, though, that a jury came back with a note. And based on the note, we were already talking about how we're going to appeal it. not really optimistic about what the outcome was going to be. And then they came back with a verdict very short after that, and it ended up being a not guilty. So I think the lesson is you never know what 12 strangers are thinking.
Yeah. So what do you think based upon that note, what do you think the entire case was pinned? Do you ever have a chance to talk to a jury after the trial is over so that you kind of get an understanding of what was going through their mind? I would think that would be really helpful.
Sometimes we get that chance. In this case, we do not. So we don't know what they were thinking.
Yeah, because I would think that if you do get that kind of an opportunity to get that sort of insight, I don't know, but you have a whole new jury the next time. And so you're thinking, okay, I'll use it based upon that jury, but the next jury is completely different.
Completely different. You never know. And, there's a saying that you learn more from the trials that you lose than from the trials that you win.
Mm-hmm. And so what amount of your time when you're going to go to trial do you spend in jury selection, and how important is that in the overall result?
Jury selection is very important. I'm a big believer that the jury can sway a verdict one way or the other. So we put a lot of time and thought into the voir dire process. Unfortunately, when the people I represent, there's already a stigma against them. They know there's a federal indictment or a state indictment against them. And, a lot of people have negative thoughts about people who are accused of crimes. So the way I look at it is you're really not trying to pick the best jurors. You're trying to get rid of the worst jurors for you. And in every case, that's different. So it's important to figure out questions you could ask to try to identify the ones that won't be as bad for you as others.
So I was just talking to an attorney yesterday who handles federal crimes, and he indicated that federal crimes, the prosecutors on those cases generally have their ducks more in a row, so to speak, than on local crime. Local prosecutors for state and local crimes. What's been your experience?
I 100% agree with that. The federal government usually investigates cases for several months or sometimes several years. In state court, things just happen. A crime occurs, a police officer sees it or a witness sees it and calls the police. It all happens very fast. So there's not a lot of development of facts and witnesses, and there's more room to find holes in the case. My experience in federal court is they do have their ducks lined up. So the most success I've had is usually not disputing what they're saying, is just disputing what they're saying, what that means. And if just because the person did it doesn't mean they did what they're charged with. That's a lot of what I do. I reframe the situation.
So give me a real world example of that concept where, okay, maybe they did it, maybe they didn't do it, but that you were able to reframe that so that the jury would think about the situation differently.
The one that comes to my head is I got a acquittal in a federal court a couple years ago. It was actually a drug and gun case. Essentially, my client was trying to buy a couple of kilos of cocaine from an undercover agent. They arrested him at the deal. Then they went and did a search warrant at his house. And in a room, they found a gun and some more narcotics. Part of the charges was that the gun was in furtherance of the drug trafficking crime. And that was a mandatory 5 years on top of whatever else he was facing. Essentially, I went out in opening and said, I'm not going to dispute anything that the government is saying. Everything they said happened. But I argued that if the gun was to further drug trafficking activity, he would have brought it with him to the drug deal he was going to go to. And their expert agreed with me that those are dangerous. People have weapons in those. People might get mugged on the way to or from those. And so that was a situation where I was able to say, look, they're right about everything that happened, but that's not what the law says. And I kind of put that burden on the jury of look, sometimes determining facts is a lot easier than following the law. What we're going to ask you to do here is to follow the law and see if they can prove every element beyond a reasonable doubt.
Oh, interesting. That's interesting take. So when the verdict came down on the McDavid trial, he jumped out of his seat and bear hugged you in the courtroom. What was that like at that particular moment?
Just a weight of relief going off of your shoulders. We worked incredibly hard on that case. We prepared for several months beforehand. When I'm on trial, it consumes my entire life. And that was a fairly long trial. I think it was 5 or 6 weeks long. plus the couple months before that. And like I said, we were almost expecting a guilty verdict based on the last jury note.
Mm-hmm.
When we heard that, it was relief washing over us.
So, I mean, you find yourself forming a personal relationship? I guess it depends on the client, but do you sometimes find yourself, and it sounds like maybe in that instance, the answer would be yes, a personal relationship with your client, or does that happen most of the time?
The way I run my practice, I think it happens a lot of the time. I wouldn't say all the time, but I like to get to know my clients. I think it helps me represent them to the best of my ability. And I have developed relationships with a lot of clients. Darryl McDavid was a little bit different because I had a relationship with him before he got indicted. So this case meant a little bit more to me because I was already friends with him for several years prior to him being indicted. And so this was the first time I was actually representing someone I was friends with that got indicted. And so that added a lot more pressure to succeed in this case.
Yeah. So, what was the crux of the charges against Darryl?
So he was charged with obstruction of justice, meaning that they obstructed the first R. Kelly state court trial in 2008. And it was possession, conspiracy to possess child pornography, and possession of child pornography, meaning the R. Kelly tape itself was the child pornography. So the whole federal case was essentially a retrial of what happened in the R. Kelly acquittal in 2008.
And so since he was acquitted in 2008, but he was later convicted of a different or something related. Am I correct in that?
Yeah, so R. Kelly had a lot more charges than my client. R. Kelly got acquitted of the same counts that my client got acquitted of. He got convicted on other ones that my client was not involved with.
Okay, so here's my curious question. So R. Kelly got convicted on a particular instance where he was the main defendant, and then they still went ahead, or he got acquitted, where he was the main defendant. They still went ahead and went after your client on the same charges later?
So it was a little bit different. What they were saying was that my client helped R. Kelly obstruct that case by paying off witnesses and telling witnesses to lie so that he would be acquitted.
Okay.
It just came out that that wasn't the case.
Okay. Interesting. How often do you have really interesting cases like that where it's just like you have to unravel a mystery or a conundrum inside of a mystery inside of a
I think every case has its own interesting points, but those kind of cases are few and far between.
So the defense team later argued the prosecution should pay $850,000 in legal fees because the case never should have been brought. How common is that kind of move?
Extremely rare. It almost never happens, and it gets granted even less. That was done after the case was over. One of the defense attorneys on our team went forward with that motion. It didn't get granted, but I think the thought behind it was it shouldn't have never been brought, and I agree with that. They shouldn't have been done.
Yeah, right. Okay, so let me try some rapid fire things. Get it a little bit lighter. So federal court or state court, which do you prefer?
Federal court.
How come?
To me, state court's a lot more like the Wild West. There's a lot less structure, a lot less procedure. And I was, when I worked for Eddie, I was raised in federal court. The first cases I worked on were in federal court. The first case I took lead on were in federal court. So I feel a lot more comfortable there. I know the players better. I know the judges better.
First thing you do when you get a new case file?
Read the indictment.
Best courtroom movie or TV show? I ask this, I get a lot of times the same answer.
My Cousin Vinny.
That's the one I get. I have to switch out of that one because I guess people like it because he's so good on his feet.
He's really good on his feet, and it's actually fairly accurate. I know a lot of law school evidence classes actually show portions of that case to show how the rules of evidence work.
Oh, that's interesting. So a prosecutor you secretly respect. Well, now it won't be secret.
There's a lot of them. I'm not going to.
Okay, I appreciate that. Guilty pleasure outside of work.
Listening to pop punk music.
One word your clients would use to describe you.
Empathetic.
Okay, that's good. That's a good thing to have as if you're a lawyer. Federal conviction rates sit at above 90%. When someone calls you after getting a target letter from a DOJ, what do you do? What do the first 48 hours look like?
Got to bring them in and get what the story is, what their side of the story is, call the prosecutor, and figure out what the investigation's about, where the client fits in, whether they're a witness, a subject, or a target, and then strategize from there how to move forward.
So you've handled everything from healthcare fraud to murder to cybercrime. Walk me through how you prepare differently for white collar crime versus some kind of a violent crime.
I think it's just more preparation because there's more to go through. I don't think it's different. My practice is I'll go through everything. I have associates and support staff helping me build the case up, but when it comes down to trial, I go through everything myself. I talk through strategies. I see the big picture. I put together my openings, my closings, my crosses, my directs. So I'm hands-on with every part of the case, no matter what kind of crime it is.
Do you do mock trials in your office or anything like that?
I have on some cases, a lot of times in criminal defense, clients have limited amount of funds. But if there are funds available to do a jury consultant or a mock trial, we'll do a version of that. I know there's recently been some new AI programs coming out that will kind of simulate a mock trial for you. I haven't tried those out yet, but definitely intrigued by it.
Yeah. So you got a federal judge to sentence the internet's most notorious spammer to time served when prosecutors asked for 12 to 14 years. How'd you pull that off? What'd you do? What was the crux of that?
He had a lot of good mitigation. I can't really go into details about what happened, but he was a unique individual, and his case was very unique. And I think the outcome speaks for itself.
So you got a federal judge to sentence. Oh no, that's sorry. Your client Peter Levashov actually thanked you in court and said your speech about his life nearly brought him to tears. How much of defense work is storytelling?
Most of what I do is storytelling. The reality of federal court criminal litigation is most cases go to sentencing. You mentioned the conviction rate. That's based on both people losing at trial or pleading guilty, which the majority of people do. And their time in court really is a sentencing hearing. And I pride myself in being able to tell my client's story to the judge. That's why I developed a relationship with them. And I've had so many clients, most of them, I would say, tell me I explained their life to the judge better than they could. I think one of the skills I have is tapping into the emotions that I felt in certain situations that might be parallel to some of theirs and conveying that to the judge, not to give an excuse for what they did, but give explanation and context to their actions.
So that Peter Levashov case was actually pretty well covered in the media. Can you talk a little bit about that?
He was they called him the top 10 spammer, right? Top 10 most wanted cyber criminal. So there's always intrigue. And when he got involved in his chosen field, it was still early on with the internet. So he's one of the original players on the internet in cybercrime. So that's why he kind of got this, I guess, reputation about him.
Mm-hmm. So what's the biggest mistake people make in the first 24 hours after they learn they're being investigated?
Think they're smarter than law enforcement and talking to them.
So there's a reason why they have the right to remain silent.
Of course, and I think what most people don't know is if you're talking to a federal agent and you lie to them, that's just a crime in and of itself. And if they ultimately can't even get you for what they're investigating you for, they could charge you with a federal felony for lying to a federal law enforcement officer. And it could be a small lie, but if they think it's material, you're going to get yourself in more trouble than you need. So my advice always is, if you think you need a lawyer, you need a lawyer.
Mm-hmm. So you've been doing criminal defense since day one of your career. What made you decide to go from Jensen's firm to launching your own? I guess.
I got a few job offers after Eddie retired. He begrudgingly retired. He never wanted to close down the practice, but he got sick. And I was getting unsolicited job offers from people that I've met in the, courthouses who've seen the work I do. And I kind of just decided I wanted to bet on myself and see where it goes. I could always get a job with someone else, but I wanted to take a chance on myself.
So what was the first week like when you put up a shingle?
Got to figure out where the money's going to come from. As a business owner, that's still something you think about every month. You have a good month and you multiply by 12 and you think you're going to be rich. You have a bad month and you think you're never going to eat again. And it never changes.
So what do you do to keep clients flowing into your office?
I think our results speak for themselves. We're very good at communicating with our clients. We don't get any kind of complaints about that. We show them that we care. We show them the work product that we do so they know that we're working. They show that we advocate for them, get good results. And most of my business is word of mouth referrals, either from other lawyers or past clients. So I think the way we work and the work results, so it doesn't.
Okay, so you recently launched. No, this is the part that my researcher messed up on. So and let me make sure that this is right too. So you're writing about extradition on LinkedIn and building. No, that's not right either. So you got a 2025 Chambers ranking for white collar crime in Illinois. How much does that kind of reckon? Is this correct?
Yeah, Chambers Spotlight, they started a new subdivision of Chambers rankings for smaller firms like mine. And I've been recognized by them for 2 years in a row now.
So what percentage of your clients are white collar type criminals versus violent criminals or other kinds of?
Sure. I think it's a healthy mix. It just depends on the administration. It depends on what the priorities are. I think the administration right now, the priorities are more violent and drug crimes than white collar crimes. When it's a Democratic administration, it's a lot more white collar enforcement. But a lot of my practice isn't just white collar crime versus not white collar crime. A lot of it's white collar individuals who find themselves charged with not white collar crimes. So a doctor or some other kind of professional whose license might be at stake because they made some other kind of mistake, I'll represent them in those kind of cases as well.
So what happens if somebody comes to you and they're broke? I mean, it's kind of, but you feel like this is a case that's worth taking. I mean, you can only take so many of those kinds of cases, and some of the more famous type ones. Then that those are going to take the most amount of time. How do you manage that, or do you just have to kind of decline?
The unfortunate reality is I do run a business, so I can't help everyone I want to help. Money does come into play, but if it's a cause or a scenario that I'm sympathetic to or a client I'm sympathetic to, I'll make an exception. Obviously, I don't like advertising that I do free work, but I think a lot of it is sometimes clients run out of money as I'm representing, and I'm pretty good about being lenient with that. My rule is usually I'll give you a break on the fees unless you're rude and disrespectful to me. Then we're not going to continue with the representation.
Yep. So you said being on trial is not just a job, but a way of life. What does that cost you personally?
A lot. That's a loaded question, but I was just at lunch with someone today and I was joking about this. I tried a federal case in Cleveland 2 months ago, and my wife was actually happy that I was out of town for the trial because I'm miserable with when I'm in trial mode.
So what is it? Do you have children too?
I have 2 little kids. That's a new thing I'm juggling with my professional career.
Yeah, how do you do that? Because I know being a defense attorney in your sort of situation can be pretty demanding on your time. How do you juggle that with the wife and the kids and then everything else that's going on, running the business, practicing law?
2 things. My wife is very understanding and very good about it. And I'm still learning. I don't know if I figured out the best way. I don't know if it's a work-life balance or figuring out how to integrate work-life.
Me too. I've been married for over 40 years and I'm still learning. I'm an awful slow learner.
It's never too late, right?
It's never too late. So you talked about growing up feeling underestimated and overlooked. How much of your drive revolves around that idea?
I think a lot of it's kind of what we talked about earlier, where I have this ability to tap into the emotions I felt in certain situations in my life and project that through my client's story to a judge or a jury and have them sympathize with them. And I think it comes off a lot more authentic when you could draw that parallel from your own experiences. Because whether a judge or a jury, I think they could tell when you're acting or being over dramatic about something. But if you're being authentic and drawing from something that you personally experienced, they understand that, and sometimes that helps them tap into their own emotions that they felt in similar situations.
So what keeps you up at night, the night before a verdict or the night before closing argument? What goes through your mind?
Overthinking everything. I'm a worse overthinker after the verdict. Regardless of whether I win or lose, I'm going to think about how I could have done things differently for 2 or 3 days, and it'll take me a while to even wind down from trial. When I'm in trial, I kind of get in the zone, and, you start off nervous. Every trial, I start off nervous, butterflies in my stomach, and, you get confident and comfortable as the trial progresses. So by closing argument, I have a good grasp about what's going on. But it's after that verdict that a lot of the anxiety starts creeping in as you try to integrate back in your normal life.
I think that's probably true in most professions. There's just more implications as if you're in your type of profession. So if someone's watching this and they're in trouble and they say, "Oh, Vadim, he sounds like he's on the ball. I need help." How do they get in touch with you?
I'm easy to find. You can find me on my website, glozmanlaw.com, or on LinkedIn, or my office number is 312-726-9015. And that was one thing Eddie left for me, was his office number and his desk. So I pay homage to Ed Jensen with my office number.
Well, Vadim, thanks so much for coming on the podcast. I really appreciate it, and you're a great guest.